Hello everyone and welcome to today's webinar on advocating for your loved ones with autism. My name is Vincent Myers and I'm the Communications and Outreach Specialist for SPARC. We're so glad that you could join us and we thank you for taking the time to participate in the SPARC community. SPARC's mission is to build a research community of tens of thousands of individuals with autism and their families who will be asked to register online and share genetic information via saliva kits sent to the home. These data are shared with SPARC researchers and will provide important new research and will power important new research that aims to advance the understanding of autism and provide meaningful information and resources to participants. Before we begin, I'd like to say just a couple of words about how today's webinar will work in case you have never attended an online meeting before. Today's presentation will be shown in a window on your computer and the sound will come through your computer speakers. If you're having trouble hearing the presentation, please call the phone number at the top of the presentation browser window. We are recording this webinar and will post it on the SPARC website so it can be viewed at a later date. Please be aware that in order to minimize disruptions, all audio except the presenters will be muted for the duration of the webinar. If you speak, we will not be able to hear you. However, you can use the chat box at the left of your screen to ask questions, either technical or for the presenter, and only the leaders of the webinar will be able to read them. Near the end of the webinar, we will leave time for a question and answer session, which will draw directly from your questions in the chat or sent to us via email to the email address we included in the reminder. Please note that the speaker is not able to provide advice regarding your child specifically, but he is happy to answer other topical questions. We'll also be holding webinars monthly on a range of topics, so questions on those topics can be addressed at those times. I think that's all of the webinar information I have for you, so I'll pass it off to Pamela Feliciano, SPARC Scientific Director, to introduce our speaker.
Thanks, Vincent. This is Pam Feliciano. As a Scientific Director of SPARC and a parent of a child with autism, it's my sincere pleasure to introduce our speaker today, Gary Mayerson. Gary is a very well-known advocate in the autism community and the founder of the first civil rights law firm in the United States dedicating to representing individuals with autism. His firm's practice areas include bullying, inclusion, housing, employment, vocational training, IEP development, and many other situations facing families affected by autism spectrum disorder. We're thrilled to have him here today, and we encourage you to submit your questions for our Q&A. We'll take questions about halfway through and then at the end. So I will just turn it over to Gary.
Thank you very much for having me. The first thing I was thinking about was why is there need for parents to be advocates for their children? I mean, it seems like kind of a silly question, but I thought of two things. The two things that are driving these disputes, why parents need to know how to become advocates, is because when you're dealing with autism, you're obviously dealing with a need for very highly individualized programs because every child with autism is completely different from another. The second phase is the absence of clear standards. Because parents often will ask us, well, what is FAPE, this thing called free and appropriate public education? That's supposed to be the legal standard. And what's amazing is that the word FAPE is not even defined in the IDEA statute, the Individuals with Disabilities Education Act. So parents really are kind of a loss for instruction or direction as to what they should be expecting, what kind of standards are applying. So they will go to the school district and they will be told, we don't have to give you what is best. We don't have to give you what is optimal. And that is true. We don't have to give you the Cadillac, but only what they call the serviceable Chevrolet. That's from an older case from called Tullahoma. But still, you really don't have much idea about what is this standard. Going back to the Rowley case from many years ago, it has to be more than what they call de minimis benefit. Again, it's really like a jellyfish trying to throw it against the wall. You really still don't know. And here in the Second Circuit, they're talking about something that's reasonably calculated to produce a meaningful educational benefit. A little better. So we have this upcoming case in the Supreme Court of the United States. It's called Andrew F. And if you look at the first slide, take a look at that case. That case is going to be coming up. The Andrew F. case is probably going to be coming up more like around January, February, March of next year. This is the main event. The Supreme Court is going to be deciding whether or not the standard of care is something called some benefit, a some benefit test, sounds very low, correct? Or whether it has to be a meaningful benefit. I'm going to bet that the Supreme Court is likely going to be going with the meaningful standard, because especially when you're dealing with autism, you're talking about the need for a meaningful standard. If you don't have meaningful educational services, you're lost. So I'm going to hope that our Supreme Court is going to make the right decision. We're waiting for the ninth justice to be confirmed. Obviously, that's going to be a big issue in the next months with the election coming up and post-election festivities. And it's very important that the ninth justice be confirmed, because the current rule is if the lower court, that is the Court of Appeals, goes 4-4, whatever the result was below sticks. So if you're looking for any kind of change and you need change, it doesn't bode well when you only have 8 justices, especially when you have a 4-4 result, which may split along party lines. There's another case which is related to the meaningful standard of care, which is called the Fry case. That is going to be heard on October 31st. I'll be there watching the arguments. Autism Speaks put in an amicus brief in support of that matter. That's really more about exhaustion of administrative remedies and what kind of claims parents are allowed to bring when they have to exhaust their administrative remedies in the context of an administrative hearing. I'll give you for example. What happens if you bring an impartial hearing and you need to bring an injunction to stop bullying that's going on in your school? The Fry case is going to be about whether parents have to wait to exhaust all their remedies first, or whether they're allowed to bring that extra claim for the injunction in the context or before the administrative proceeding is concluded. It sounds very complicated, and in some respects it is, but it's a complicated procedural case that will have tremendous implications for parents as we go forward. So if you take a look at the second slide, which I'm going to click on here, in addition to this FAPE standard, which the Supreme Court is going to be defining a little better for us, the FAPE has to be delivered in what they call the student's least restrictive environment, otherwise known as LRE. And least restrictive environment is one of the only, there's only a handful of maximizing standards in the IDEA statute, and this is one of them. And the rule is basically this: that children with disabilities should be educated with non-disabled peers to the maximum extent appropriate, maximum extent. So LRE is a continuum, and it could be anywhere from reverse inclusion, where they're bringing in other children from a mainstream school into your child's special education classroom, or it could be your child mainstreaming in a school that's designed for typically developing children. And we have to be a little bit careful about mainstreaming and inclusion, because while there are many students who can clearly benefit from inclusion or mainstreaming, it's not for everyone. You don't want to have a child that needs a great deal of special education support, is in essence being plunked into a classroom of inclusion just for the sake of having the bumper sticker that says my child's in an inclusion class. So that's a personal decision that parents need to make with their educational consultants and from assessments and evaluations. Some principles about least restrictive environment, however. It applies even at the preschool level. Some school districts believe that it doesn't start until a child is 6 or 7 years old. Wrong. If your child is 3 years old, you should be thinking about whether or not LRE is a consideration for your child. We had a case about 2 years ago which had to stand for the principle that least restrictive environment applies to the summer months. So if your child is a 12-month student and they're going into an inclusion or some kind of mainstream experience during the September through June period, the summer program, it can't be the school district saying, well, we only have a self-contained classroom for the summer, take it or leave it. This court says that if your child is mainstreaming during the year, they're entitled to those kind of benefits during the summer months as well. Now this last piece here about least restrictive environment applies even if aids and supports are needed. There is no requirement that your child has to earn the right to an inclusion experience. Some districts will say, well, if your child needs to have the aids or if you need to have these supports, then they should really be in a more restrictive setting. Wrong. Congress has mandated that even if your child needs these additional aids and supports, there is a preference for mainstreaming, a preference for inclusion, because they want your child to have the socialization opportunities, the communication opportunities, and the ability to be able to model appropriate behavior as well. So there's no requirement or need to have to earn the right to inclusion. Related to least restrictive environment and the maximizing of inclusion situations is the idea that all students should have access to the general curriculum to the maximum extent appropriate. Again, this is one of only a handful of maximizing requirements in the statute. So when we talk about the general curriculum, we're not necessarily saying that your child needs to have the actual full general curriculum. In fact, if your child is in an inclusion situation, you may need to modify that curriculum to bring it down to a level that would be understandable and usable for your child. So somebody has to modify that general curriculum, and that is also another point of contention sometimes between school districts who really realize how much time is involved with modifying the curriculum, but if it needs to be done, you have the right to that. The last piece on least restrictive environment is sort of an admonition that parents really need to be very careful and monitor the situation very, very carefully. There's a gap between a child that has autism and a child that's neurotypical, at least typically there is. Is that gap growing or is it closing? If you're working on an inclusion program and a year has gone by, does your educational consultant, your inclusion expert, believe, based on data, that you're really making progress, or is the gap growing? And if the gap is growing, what do you need to do to make that inclusion program work? And if it's not growing, what do you do? So you need to assess what you're doing right and what you're doing wrong. And there are people out there who are inclusion specialists who know best how to help you manage that situation and assess the situation. So we're on to the next slide, which is about the importance of assessment. This could not be a more important topic. When parents come into the IEP room, the school district will often want to, or sometimes they will do it openly, roll their eyes because they're thinking, this is what these loving parents want. I can't blame them for wanting it, but we don't have to give what parents want. So constantly we're focusing on trying to change that dynamic. You want to change the dynamic from, quote, this is what parents want, to, quote, this is what professionals are recommending. Once you change that dynamic, you're way ahead of the game. It's very, very difficult for a school district without its own assessments to combat parents who come prepared with good assessments and evaluations, make recommendations. And by the way, parents should not go to anyone who is afraid to make a recommendation. Often the school district's evaluations will end with no recommendation. I don't see how that's possible, how that's at all helpful to the situation. If a parent is interviewing a person as a potential source of evaluation, the first question is, at the end of all this, will you make recommendations? The answer has to be yes. Parental cooperation in the assessment process, absolutely critical. Parents really have to be erring on the side of saying the word yes whenever the school district says we would like to conduct an evaluation or we'd like to do an assessment. There are some limits. If the school district wants to send you 1,000 miles away to another state, you may have something to say about that. Or if they want to do a week's worth of evaluations, there may be some limitations. But in general, parents should be ready to say the word yes and should consent to the bottom line. Of course, when parents consent to evaluations, they should ask the district, I will consent on condition that I be given a copy of the evaluation results when they're available to you. That's a reasonable request. Parents often ask me, well, how do I get an independent assessment? And can I get an independent assessment at school district expense? The answer is, it's twofold. It's a two-track system. If you look below, parents who can afford it may gain an edge if they do their own early private assessment. And then they're very expensive. I mean, I recognize that many assessments and evaluations can cost thousands of dollars. So a parent may not be in the position to be able to afford a private assessment. It may need to first go through the process of getting a regular assessment from the school district. But if you do that, go through that process, and you get the assessment from the school district and you're not happy with it, maybe you think that it doesn't really depict your child accurately. If you're not satisfied with the school district's assessment and the school district went first and did its own, you can write to the school district, express your dissatisfaction with their assessment, and ask for an independent assessment at school district expense. I'm not talking about choosing from a list that the school district provides. The independent assessment is exactly that. It comes from the parent. So you could send a letter to the school district that sounds something like, I got the assessment you did on my child. I don't think it accurately represents what my child is all about. I would like to have Dr. X do an independent assessment at school district expense. Please advise. And then they have I think they have 30 days to decide if they're going to give you the independent assessment. And typically, it costs the school district so much money to have to go to a hearing to contest the issue of an independent assessment that for the few $1,000s that it might entail, you're likely to get it paid for by the school district. But I do recommend that those, especially when we're dealing with autism and we're dealing with a myriad of different needs and deficit areas that have to be addressed, that parents can save months of very valuable time by getting an edge with an early private assessment. If you can at all afford it and stretch your economics so this can happen, I think it's the way to go, because otherwise you might lose 6 months or a year screwing around with assessments that are not satisfactory and aren't really telling the tale. And there really are assessments for absolutely everything. Assistive technology, if you have a child who would, by a certain age is not displaying any expressive language, you may definitely want to be getting involved with that. Transition planning, which I'm going to be talking about in a little bit. Vision therapy, nonverbal cognitive measures, it's all there. So don't let the school district ask you, well, what assessments do you want to have done? You should talk to other parents. You should take a look at the possibility of consulting with an expert in the field so that you can determine what assessments your child needs. Don't let anybody pigeonhole you into just a few assessments, because the one assessment you may need is hopefully not the one that they fail to do. This happens a lot with assistive technology, where sometimes we'll say to the district, you didn't do an assistive technology assessment. And they'll say, well, the parent didn't ask for one. I said, well, how is the parent supposed to know what is entailed in an assistive technology of assessment or evaluation? That's your job to explain that to the parents. So at this point, I think what I'm going to do, actually I'm going to go through one more slide, and then I'm going to take a break for some questions. The next slide is what happens at the IEP, at least what's supposed to happen at the IEP. Now, when parents come into the IEP room, it's usually one or two parents, and they're shocked to see that there might be a dozen or more people surrounding a table. It's hard to believe that there's so many people there for your child. But somewhere underneath all that paper, your child is there. Trust me, they're there someplace. When you walk in the room, you should ask the person who's in charge, how much time has been allotted for this meeting? Because if you have concerns that you want to address and you know that there's only a half an hour, your timing may dictate when you open your mouth. You should have received notice as to who is attending. You should not be surprised they should not be surprising you with somebody coming, like an attorney from the school district, if they didn't give you notice that that person is going to be there. So you'll check your notice in the mail. I wouldn't abort a meeting if I saw someone who was a surprise attendee, but just note it. The important principle on this going to these meetings is, by all means, disagree, but never become disagreeable. Because if you do become disagreeable, it'll be noted in the records, and if you ever have to bring an impartial hearing, the last thing you want is for them to say, oh, the parent was obnoxious, the parent was making threats, or the parent was doing something that was unreasonable, like not consenting to evaluations or assessments. By all means, take notes, but whatever you do not surreptitiously record. You're entitled to record if you wish, but when you do that, my sense is that it communicates a great level of distrust. I would only record a meeting if I was already at loggerheads with the district and it was already open that there was a conflict of some kind. Now, these next 9 items is the order of at least what's supposed to be happening at the IEP meeting. It doesn't always work this way. First, they have to determine your child's eligibility for classification, and just that you're entitled to special education services. Merely having some form of disability doesn't automatically make you eligible for services. It often does. So are you going to be eligible for an IEP, or are they going to offer you potentially a 504 plan, which you might get even if you don't fully qualify for an IEP? This is when you want to share and review any assessments. If you've done your own private assessments, this is the time to be sharing them with the Board of Education or the school district you live in. This is the time to share pressing information. Is there any bullying going on? A huge issue these days. Is there a safety or danger issue with elopement or some other safety issue that you want to bring up? Your child's behaviors. Do you need something called a functional behavioral assessment? Are you going to need a behavior intervention plan? Are there interfering behaviors? And who's going to be managing that? Are there any special allergies? This is the time for you to bring up all these extra things that may just apply to your child. Then they want to determine what's called present levels of educational performance. This is typically based upon assessments, because unless you know exactly where your child is, there's really no way to develop goals and objectives as to where your child should be in 6 months or a year. So they really need to assess and know what are present levels of performance. On this topic, I encourage parents to have their IEP meeting as late in the school year as possible so that the present levels are as close to the next year as possible. You don't want to have an IEP meeting necessarily, let's say in October, this month, for an IEP that you're not going to implement until next September. Your present levels will not bear any relationship to the present levels you would obtain if it was more in the spring. So you want to time these assessments properly, if at all possible. After you do the goals and objectives, which they need to be sufficiently challenging, they need to be comprehensive, addressing all the different deficit areas, they need to be measurable, and they really need to be pointed in the direction of independence and self-sufficiency. So for example, let's say your IEP goals and objectives talk about prompting. What kind of prompting? Are we talking about physical prompting, hand-over-hand prompting? Are we talking about gestural prompting? Are we talking about just somebody giving a look? I mean, this is the prompt hierarchy, very important. But the goals and objectives over time should be pointed in the direction of self-sufficiency and independence. At the end of this thing, I'm not saying you're going to get it on the day of your IEP, but they will certainly generate, or are supposed to generate, a new or modified IEP document for you. And they're supposed to also give you a piece of paper that gives you notice of anything that you requested that they refused and why they refused it. And following the IEP meeting, this is when you're going to be thinking about, do I want to object to the IEP? Do I need to file for a hearing? And do I need to request pendency, which is essentially maintaining the educational status quo pending a decision on your case. So, for example, I'll give you a pendency example so you'll understand immediately what this means. Let's say your current IEP says that you're entitled to 5 hours of speech therapy. And your new IEP meeting, they say, we want to reduce the 5 hours of speech to 1 hour a week. And you say, I don't think that's adequate. You could file a request for a hearing and ask for pendency. Pendency is the protection that will keep your services alive at 5 hours a week until the hearing officer decides otherwise. So at this point, having gone through the basics of the IEP process, I still have some more slides to go through. I think this would be an appropriate time to take some questions and see where that goes for about 5 or 10 minutes.
Ramifications of this case. Like, even if they decide meaningful or some, besides the semantics, what will, how will schools act differently if the decision is favorable?
Well, we're all going to define differently what a favorable decision is. When you're the school district, you have your own view.
Right.
But obviously, it will set the basic standard that the school district must comply with for them to be in compliance with IDEA. So I don't think we have to worry too much in the Northeast, because the New York courts and Massachusetts and New England are basically signed on to this meaningful standard. I think that even if the court were to say that they're requiring a some benefit standard, I believe that inertia would stay the course somewhat, and that at least in the Northeast and in California and some other states, that this meaningful standard will apply. But it is a dangerous time. I mean, obviously, if the Supreme Court were to say that all you have to do to satisfy services is give some benefit, it's really hard to mess up a some benefit standard because somebody can always point to something that they did right. That would seem to be very close to the de minimis standard that the Rowley Court said was no good, which is why I'm betting that the Supreme Court, even the most conservative justices, may very well sign on to a meaningful standard as thinking that's the least that they can do, particularly when you're dealing with autism. And as I mentioned before, there are a number of advocacy groups, including the Justice Department, by the way, who have weighed in on the subject and said there must be a meaningful standard. You can't have a standard as low as a some benefit standard. So we'll have to wait and see. I think everyone needs to be concerned about this, and it's a watch and wait, but I'm going to bet that the Supreme Court does the right thing on this one.
Okay, good to hear. One question, it's specific, but I think it can be applied more broadly. So the person is asking how they would go about or how they should go about advocating for a one-on-one for their child. But I think it can be broadly casted as how do I go about advocating for something that I know that my child needs? Like how do I even begin to approach this? Do I have to wait for due process, or how can I proactively do this?
Well, I think on this one, the assessment process is coming to your aid. You would need to have either a behavioral consultant or somebody be able to, like going back to the need for a one-on-one, either an aide or somebody of a higher caliber of training. You would need to show that your child is unable to learn except on a one-on-one instruction basis. And this is going to tie into the next slide after we get done this question, which is, and this ties in also to ABA. I might as well just basically just go right to that slide because this is, I think, a perfect time to talk about that.
Okay.
Making the case for ABA. So your question was, for example, how do I make the case for if my child needs a one-to-one?
Right.
So notice that the second bullet happens to be how to make the case for one-to-one instruction. Okay. So I just want to make sure I can blend these two. You need to be able to show that your child's learning style, that your child does not learn except with one-on-one instructions, and not just support, because there's a difference on that. Your child, especially a child that has autism that may be very responsive to applied behavior analysis support, may very well need one-to-one instruction in the classroom on a full-time basis. Assessment will tell you, because they will do a pre-test and post-test measure with and without the support, and then somebody can make a recommendation in saying, well, because Johnny didn't learn anything during the probing and trials that we did without the one-on-one instruction, but did do it once we provided one-to-one, this proves that he needs to have one-on-one instruction to learn things or to maintain his skills. So I think it's an assessment issue, and that's another classic example of how an educational consultant or a behaviorist can come to a parent's aid. So if I could just continue working on this, making the case for ABA.
Yep.
Parents will often say to me, well, they don't want to talk about ABA. They refuse to discuss methodology. And that's a big point because the school districts have learned, because of the case law, that they don't have to necessarily resolve a methodology dispute. ABA versus whatever, teach. Maybe it's the DIR or Greenspan approach. It could be any number of approaches. You don't want to be warring with your Tylenol against their extra strength Advil. That's not a good fight to be having. So you basically break it down to its more generic components. You don't talk about ABA so much. You could talk about the need for one-to-one instruction. You could talk about the need for prompting and reinforcement. You could talk about the need for fading. All of these things have to do, obviously, with ABA, but you don't have to basically say the word ABA in order to justify the need for the components of ABA. You also may have tried non-ABA approaches that may have failed. And by the way, it works exactly in the reverse. We've had some students, few, but some students, who tried ABA programs and failed in those ABA programs and who are now doing either a TEACH or a DIR program because the ABA didn't work. It's most often exactly the reverse of that. Most often, ABA is the only thing that works for the child, but I've seen it on both sides. It really depends on the individual needs of the child. And then when you're talking about ABA, you're talking about what kind of ABA. Is it natural environment teaching? Are you talking about discrete trial? Are you talking about incidental learning? Or are you talking about all those things? And if you are doing ABA, and even if the school district is warm to it, you want to be able to build in a fading of the ABA support over time towards independence and self-sufficiency, always. And based on progress, not the calendar. You never want to see an IEP that says, Johnny is going to be getting an ABA C until December, but when New Year hits, we're going to take away the support. The calendar, autism has no idea what the calendar says. So it's always based on the progress of the child and not the calendar ever. I tell parents, look, ABA is not a religion. You're doing ABA to get out of having to do ABA in the future. It's almost like jumper cables that you put on your car. Once you get the car started, you have to know when it's time to start removing the jumper cables and to drive off. So I think, are there any other questions that I could probably take one or two briefly before I move on to the transition issues?
Yeah, there are a few. How about this one? There's some confusion about when the ADA applies in the school setting. So there's a private device that's supported, but not necessarily required for the FAPE. So how does that work?
I'm sorry, I want to make sure I understand. Did you say ABA or ADA?
ADA, the Disabilities Act.
Okay. Well, the ADA, which was enacted back in 1990, applies to schools as well. It applies to private schools. It pretty much applies anywhere where there's a public accommodation. So you might have, a child might have ADA issues. Basically, if a child needs an accommodation of kind, that's what we're talking about when we're talking about the ADA, Americans with Disabilities Act, the need for public accommodations. So this can be a number of different things, but essentially the rule is if your child has a disability and needs the accommodation, it might be after school services, it might be extracurricular things, you're entitled to an accommodation unless giving you the accommodation so fundamentally changes the thing that you're doing that it ceases to be the thing that you're working on. So for example, trying to come up with the context so it would be immediately understandable. If you're talking about the Washington Monument, the Washington Monument would not look like the Washington Monument if there was a requirement that somebody had to put in special elevators on the outside of the building to ride up the side of the Washington Monument. So that would never, I don't believe, would be required. But if there's something that they could do in accommodation so that somebody in a wheelchair could get up within the structure of the Washington Monument, they probably would be required. So there's all kinds of accommodations in school, whether it's approximate seating, you name it, which would come under ADA. But many of these ADA accommodations also could be justified under the IDEA. So it's not like they're necessarily mutually exclusive when you're talking about the school setting. And I don't think it really matters which label you place the accommodations under, as long as it's written somewhere, either in a 504 plan or more preferably in an IEP document, you're protected.
Okay, I think the question here, maybe this will help also with a person. So there's a communication device that is, trying to be used at school. The school district is saying the device is not protected under ADA if it is not accepted as part of FAPE. So is that true or not true?
That's not true. Again,
Yeah.
For example, let's say if somebody wanted to use an FM device in the classroom. I don't know what kind of device this particularly is, but if it was horrendously disruptive to the rest of the class, then the school district might defend and say it so fundamentally changes the classroom and it also impacts the education of the other students, we don't have to do it. But if it's a reasonable accommodation that does not fundamentally change the makeup of the school or the classroom, they've got to do it. They've got to accept it. They may even have to pay for it.
Okay.
Maybe I would say one more question, and then I can go on to transition if there's another question I could answer.
There are two questions from people in Texas saying they're facing major issues with getting denials They say they've gotten in denial even though they're, had a professional evaluation, had a diagnosis for autism. So I guess in that case, the assessment doesn't help. The school offered to do a second evaluation. Can the parents ask if they return the report quickly rather than having to wait the normal wait period?
When it comes to Texas, I have to be very candid. We've had cases in Texas. We've done 35 states around the country. Texas is a tough state, or at least historically it's been tough. I think it has actually gotten better in the last 5 years, but we continue to hear these horror stories. And when we hear them and we discuss what the parents' problem is, more often than not, we're asking the parents, are you able to move to another state? And, when you talk about parents that have to move, because thousands do move across the United States, even from good states from time to time, Texas is just one of those tough. Louisiana is another state. So we see the school districts in Texas, and they're not the only one. Could be Mississippi, Alabama, Louisiana. I could go through them, where there's a clear and unequivocal right, and the school district just says we're not doing it, and they dare the parents to bring them to due process, figuring that because you have an ARD process in Texas, they call the IEP, meaning the ARD. It's an ARD process. It's the same thing. But boy, it's a completely different approach. It is, I wouldn't say next to impossible, but it's often next to impossible for parents in that state to get appropriate services. It's really a shame.
Okay.
All right, so what I think I'm going to do is I want to make sure we have time for more questions at the very end. So I'm going to spend a little bit of time on the transition to adulthood, which is, for me, the holy grail. I mean, the whole purpose of doing all this is so that at some point when you age out of the educational system, and that will happen, that a person is able to transition and graduate to something that's meaningful. Every year, I think the statistics are that 50,000 individuals with autism will make the transition to adulthood in the United States. That's every single year. And if you look at the unemployment statistics, the only dispute is how bad it is. It's bad. No matter how you slice it, it's bad. It's at least 75, 80%. Some people have said it's more like 90, 95%. So Congress, amazingly, our Congress, at the time that they came out with the 2004 reauthorization of the IDEA statute, they had the right idea. Congress wants to have equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. Terrific, wow. So how do we get there? Is it a bridge too far? And there's other sections of the IDEA statute that talk about something called transition services. And these transition services are exactly what are preparing students for their lives as adults, or at least that's the idea. And they're defined in the statute. I'm not going to read it out loud, just to save a little time. But if you look under A here, this is what the transition services are defined as. And they include all kinds of things: instruction, assessments, acquisition of daily living skills, functional vocational evaluations, and training. It's huge. And I would say this is the most overlooked section of the IDEA statute ever, but it's being looked at now with a fine-tooth comb, because school districts are realizing that parents of children that are becoming adolescents and getting close to adulthood are asking about transition, because they should be, because they're getting smarter about this, and parents are realizing, how is my child going to transition to something? How is my child going to have any hope of living some kind of a relatively self-sufficient or independent life? And it's a continuum. Obviously there are going to be students with autism who will transition to adulthood and who will live in institutional settings. I mean, that's a reality. But many, many, many more will wind up being in some kind of a halfway situation. They may be living in the community near their family members. And this whole transition assessment planning needs to start very early. You don't start it when you're 18 or 19 or 20 years old. If you look at the next slide. Thank you. Okay. So when does this all happen? Well, it depends. If you're looking at the federal standard, the IDEA statute talks about IEP year when your child is going to turn 16. Well, if you have an IEP meeting in May and your child is going to turn 16 in September, they need to be talking about transition at that IEP meeting back in May. You don't wait until your child actually turns 16. And in New York, and I believe in a couple of other states, it's even earlier. In New York, it's 15 years old, and it may be earlier if indicated. But once your child is in that 15-year-old range, you really should be looking at getting a series of vocational or other assessments to figure out what your child's interests are, or even if they don't express any interest, what interests might be teased out of them. Perhaps it's culinary arts, learning to be a chef. Perhaps it's music. Perhaps it's computer skills. There's so many things to be looking at and figuring out what are the areas of potential that can then be trained up into something that would be employable. So the last portion of the last slide says you have to build it into the IEP to include, quote, appropriate measurable post-secondary goals based upon age-appropriate transition assessments. When your child is 15 or 16 then, you can't miss the mark. You can't miss the market. You've got to get those transition assessments done then. They need to be done in an age-appropriate and developmentally appropriate way. And don't let the school district tell you, oh, you've got plenty of time, because you don't. You don't have this time. Every year counts, and you must be able to get these assessments and goals underway so that if you have a mediocre or even a bad year, you still have some elasticity in your program to get it done by the time your child is 21. And these services can be anywhere from vocational training to go on to a college-like or even a college experience. So it's a full continuum of post-secondary goals. It's neither, parents shouldn't assume it's only vocational training because it's that much more. But we have a class action lawsuit pending right now in New York City because New York City, we allege, has not really been focusing on transition. And we can't have social promotion from year to year where the ultimate graduation is basically walking off a plank into the unknown. Parents, we parents don't live forever. We may not even be healthy forever. So we have to be able to plan for the days when our children will be able to become adults and will have some skills so that they can move on with their lives and hopefully be as independent and self-sufficient as possible. So with that, I think I'm going to take some more, the balance of the questions and given the time constraints.
Okay. Someone is asking about how transitions should be planned differently for students that are graduating.
Well, if a student is graduating, you're talking about a student who's going to walk down and take their diploma with the other students in the high school and get a regular diploma? I'm
not sure.
Okay.
I think so.
Well, it depends on the functioning level of the child. But if you have a child that you're thinking or you're not sure, gee, is my child possibly going to be going? Maybe they're going to go to community college. Maybe they're going to go to a regular 4-year school, or maybe they're just quote unquote, I hate these terms, high functioning, low functioning. I really do hate them, but parents use them and I need to be able to use them so we have some idea of what we're discussing. That if a student is on track to get a regular diploma and there's still uncertainty about where that child is going to be, it's the parent's election if the parent wants to have the child graduate at 18 and the child is sort of on the fence there. But that child's transition services would start at least no later than age 16. So they'd have 16, 17, 18, at least several years worth of transition planning and services before going out into the wild world out there. But you can have a situation where, I've seen this, where the school district, they look at the child sometimes as a hot potato that they want to get rid of. They go, oh, your child is going to be graduating this year. You're going to get a diploma and walk at graduation like everyone else. And the parent's all excited about this. And then comes to the realization, my child has no skills. My child doesn't even have activities of daily living and can't even go to the bathroom properly, perhaps. And they're going to go walk the walk and get this diploma. Parents who are on the fence, who don't have their children, don't have the skills to be self-sufficient or independent, really be thinking about, do I really want to be taking that walk and getting that diploma, or should I allow my child to stay on until the age of 21, and in even a couple of states it's even longer than that, but you get another 2 or 3 years worth of services and training may make the difference between a greater sense of self-sufficiency and independence. So I don't know if that answered the question, but those are the kind of considerations I'd be thinking about. Child graduating at 18 versus a child sustaining until at least the age of 21.
Yep, I think that did answer. One question, how, and this is again the meaningful appropriate. Someone's asking, is meaningful going to be as vague as appropriate is?
Good question. I think the answer, in light of the 5 cases that have already tried to define what the standard is, it may be not as amorphous as it is now, but I'm not expecting there to be any perfect definitions. I don't think that we're going to walk away from the Andrew F. case with somebody breathing a sigh of relief. Oh, now we know exactly what it's going to be. But it will give, I think, the circuit courts and the district courts, the impartial hearing officers, I believe, a greater sense of direction about where they should hang their hat and what kind of analyses to apply to an individual situation. I think it's still going to come down to need. If you have a child with autism who needs speech therapy or needs an assistive technology device, if they need it and you can prove the need, I believe that that need is going to mean that you're going to get the service no matter what the standard is. But I do believe that especially with the cost of providing services and with shrinking school budgets, that school districts are looking for a way to reduce their standard of care, and I'm not sure that the court is going to permit them to do that, only because of, particularly with autism, the sheer numbers, that if we don't invest the money now, and we don't, because we're going to be paying for it with a great deal of more dollars and tears later. I think there's a recognition today that we must make the investment now, or we'll be very sorry for it later.
Okay, I hope that people are that forward thinking. Here's another question. My child was moved from an IEP to a 504 because he has a high IQ and is fully integrated. I disagreed with this, but I wasn't considered. My thoughts weren't considered because I'm not the expert. And she's worried this is a progression to take away all services and he would just be labeled a behavioral issue. Do you have any recommendations?
Well, it would depend. If I'm moving from an IEP and I'm converting to a 504, if I disagreed with the reduction, if there was a reduction of services immediately going from the IEP to the 504, I would be examining with my evaluators and people close to me in my child's program, do I really need these services? Because if the answer is I need these services, I probably would recommend to the family that they file for a hearing to maintain the services under pendency, proving, because if they could prove that they needed the services, and that the reduction or elimination of services going to the 504 was inappropriate, well, then they would be able to continue the services that the child needs, and they would also get their attorney's fees paid for, assuming they won their hearing. So I would really be looking very, very honestly about, is this the appropriate time to be transitioning to a 504? Because sometimes it is. Sometimes a child, particularly a child that's moving towards greater independence and self-sufficiency, that's the idea. You're supposed to be losing services. It's not a bad thing. It's a signal. It can be a signal of a great deal of progress. So that's how, those are the factors I'd be looking at before I'd make a decision whether to fight or not.
Okay, great. Someone is asking you to address an item on your ABA slide. So there was a note saying caution ABA schools that have no related services. They're wanting you to expand on that.
Okay. Okay. On this one, I don't want to overstate what often is not even a problem. There are a number of ABA-based schools that do everything through the ABA methodology, everything, communication, occupational therapy, and they don't necessarily have occupational therapists. They may not have speech therapists. They do everything through ABA. There are many other schools that use a more of an interdisciplinary approach or integrated approach, where ABA is the core of their program, but they also have speech therapists or physical therapists and so forth. I just think that parents need to be examining whether or not their child, depending on the assessments, whether the child may very well need a fully ABA school that has no related services. That may be exactly what the child needs, particularly if there's some very serious behaviors going on, or whether or not their child might be better served at a school that has a more integrated approach. So when I say the word caution, I'm already maybe even overstating that it's a problem. It may not be a problem at all, but a school that's an ABA-based school is either a pure ABA school or it's an ABA school that also has these integrated services on top of it. And I mean, there's some truly excellent ABA-only schools. I'm thinking of, let's say, a school like the Princeton Child Development Institute or perhaps the Alpine Learning Group. These are terrific schools, and they don't offer related services in that kind of traditional way. And it's not a problem for most all of their students.
Okay, great. There's a question here about a parent trying to advocate for extended school year. The school district is saying they have to show that his skills backslide, but how do they show that after it's happened? You know, how do you put the cart in front of the horse?
Well, we don't ever want to have a child drown to prove that they need swimming lessons. And for the same reason, a child should not have to go through a period of significant regression to prove that they regress. So the standard, by the way, does not require actual regression, but it does require an anticipation, a reasonable anticipation of regression based upon things that happen. So, for example, if a child goes on a vacation, let's say the Christmas vacation, or goes on the Easter vacation and is out for a week from school, and they come back to school and it takes them weeks to come back on track, that probably with a report from somebody who's a good evaluation expert to say, I've seen this situation, the child came back and really, really regressed even with a week, and it took weeks to get back on track, then you'd be able to say that you need to have the additional services because of the anticipation of regression. Sometimes it's called the regression statement. So I would not, if I'm a parent and I'm asking for the additional services, I don't walk into the IEP meeting and just ask for them. I have the regression statement in hand, and that is an anticipation of regression based upon some tangible things that have happened in the child's experience.
Okay, that sounds good. Someone is asking if there's an effective way to get your child's private providers access to consult with their school teachers. Because a lot of times they're like closed doors.
Well, I would make the effort. It's interesting because if you want to get paid for these these extra services, I think that the private providers need to at least make the effort to get in touch, a demonstrable effort to get in touch with the school, so they can show what they're hearing. Hey, we're really trying to integrate this, so we don't do anything, that we do everything complimentary and we don't do anything that's going to screw up the school program. When private providers make no effort at all to find out what's going on in school, or to have zero communication efforts with the school teacher, sometimes that's a point of criticism from the hearing officer. So even if it's refused, I certainly would advise a parent to have their private providers make the effort, at the very least.
Okay. Someone is asking about health insurance. So I don't know if this is something that you deal with. But,
yes.
Yeah, so they can't get their health insurance to pay, and how do they go about doing that?
Okay. Well, first of all, you have to decide whether you're living in a state. There's about 40 states now that have health insurance reform. If you are in one of those states and you have insurance, you have to have some kind of an insurance policy. Take a look at the inside of the policy. Here in New York, we've just been doing it for the last several years, and there's still some insurance companies that will give you, like any insurance company, might give you an initial resistance, but then when you insist that it's covered under the policy, eventually they get it. So we're talking about potentially between $40,000 and $45,000 worth of insurance benefits for people who do qualify. That can include ABA services, speech therapy, occupational therapy, and other related services. But on the ABA piece, there's a caveat because the people under the insurance policy who are qualified to provide the service must typically be something like a BCBA or an associate BCBA or a PhD or someone with a licensed psychologist. So you can't just have anybody under the insurance. If you want to get the insurance benefit, they need to be a qualified provider. So you look at your policy to see who qualifies as a qualified provider.
Okay. Yeah, I guess that's state dependent. We have one more question. Someone's asking if they can retroactively contest, file a lawsuit that the school district did not provide an appropriate education or lack of social integration to a student.
Okay. The answer is theoretically yes. Even if you're not going for money and you're just going for you can go for something called compensatory education. If there is a gross failure to provide the FAPE, the free and appropriate public education, I'll give you an example. Let's say a student was supposed to get 5 hours a week of speech for the whole school year, and they didn't do it for the whole year. The whole year went by, and hundreds of hours of unfulfilled services are basically what we're talking about. The parent doesn't come in and say, give me $50,000. The parent can, though, bring a case retroactively and say, I believe that there was a gross deprivation of the right to provide my child with a FAPE. I was entitled to all these hundreds of hours. My child didn't get them. Therefore, I want a compensatory education award to give me a bank of those hours going into the future so I can deliver them whenever I want. I could do it perhaps in the summer, during holidays, until those hundreds of hours get fulfilled. So yes, parents can bring a retroactive case. But another caveat on this is that typically there is a 2-year statute of limitations on these things under the IDEA statute. So parents should not wait and say, oh, something happened in 2011. You're out of luck. You're done. You're not going to be able to bring that claim most typically.
All right. Thank you so much, Gary. That's going to be it for today. I'll just read some closing remarks, and then we'll be done for today.
Thank you.
So thank you so much again for an amazing presentation, and to everyone for joining us today. You can access this webinar in a few weeks at sparkforautism.org. You can also learn more about the SPARK study and join online at our website, sparkforautism.org. Stay tuned for upcoming webinars. On November 16th, Dr. Jed Baker, Director of the Social Skills Training Project, a private organization serving individuals with autism and social communication problems, will present on managing frustration and anxiety and teaching social skills. More details on that talk are available through our newsletter and will be shared in the coming weeks. We also have a 2-question survey that will automatically appear when you close your webinar window. And if you could take a few minutes to fill that out, it would help us to provide presentations that are of the greatest interest to the SPARK community. Thank you again for joining. Goodbye.
Thank you, Gary.
Thank you for having me.
Thank you.